President Cyril Ramaphosa stated in papers filed in response to a constitutional challenge on load shedding that it does not constitute a breach of duty on his or his national government's part because the law places responsibility for electricity provision on municipalities. The president, as the eighth responded, is opposing the application filed by 19 litigants, including opposition parties, in his own capacity and on behalf of the government. In his answering affidavit, Ramaphosa argued that under Part B of Schedule 4 of the Constitution, electricity and gas distribution are the responsibility of the local government. And because nothing in the Constitution or any other law required him to provide public electricity, he could not be accused of failing to uphold the Constitution because the lights are not staying on. It is now widely accepted that municipalities are required by law to provide water and electricity to their citizens as a matter of public service, Ramaphosa said. This duty does not fall to the president or any of the national departments named as respondents herein. According to Ramaphosa, the Constitution does not prescribe what consequences must follow from the president upholding the Constitution, as Section 83 enjoins him to do, and neither can the court. The mere fact that the president's best efforts in this case did not produce the desired results does not imply that the president has failed to uphold, defend, and respect the Constitution as the supreme law of the Republic, as suggested by the applicants. Ramaphosa added that the law gave him no authority to perform or interfere with municipal executive functions. Accordingly, if municipalities do not supply electricity to their people for one reason or another, the Constitution does not require the president to go down to local government and do it. However, just because electricity was provided to municipalities did not mean that the applicants had established a case against this branch of government, he said. Section 4 of the Municipal Systems Act of 2000 states that municipal councils must provide equitable access to the municipal services to which they are entitled to residents of a community. However, this could only apply to the extent that electricity was available. If there was no electricity available for one reason or another, equitable access is impossible. The applicants have not established a case that municipalities have failed to provide equitable access to their citizens. As a result, Ramaphosa stated that the applicants' claim that the rights guaranteed in the Bill of the Rights were violated on a regular basis cannot be supported. He also stated that Section 152 of the Constitution qualified that municipalities must strive to achieve their obligations within their financial and administrative capacity. Municipalities lack the capacity required to supply electricity in situations where ESCOM has determined that load shedding would be implemented. The applicants have asked the court for a declaratory order that Ramaphosa, ESCOM, Public Enterprises Minister Pravin Gordhan, Mineral Resources and Energy Minister Gwede Mantashe, and the state as a whole have failed to project, respect, and promote the Bill of Rights. In the first, they seek an urgent injunction compelling the state to exempt certain sectors from load shedding in order to ensure the delivery of basic services such as healthcare, education, policing, water, and sanitation. The parties also request for the government to present a plan outlining the steps it will take to end load shedding within 7 days, including a maintenance schedule for ESCOM.